A very good evening to you all. It is with great pleasure that I am able to say a few words about our guest of honor, Mr. Ajmalul Hossain, QC Sir, the first ever King's Counsel in England of Bangladeshi origin and senior advocate of the Supreme Court of Bangladesh. Mr. Hossain completed his LLB honours and LLM from King's College London. He was called to the Bar of England and Wales in 1976 from the Honourable Society of Lincoln's Inn in London. He got enrolled in the High Court Division of the Supreme Court of Bangladesh in 1977 and the Appellate Division of the Supreme Court of Bangladesh in 1986. He became a senior advocate of the Supreme Court of Bangladesh in 1998, and in the same year he was appointed as the then Queen's Counsel, as it was back then known, of England and Wales. Mr. Hossain is also a registered foreign lawyer of Singapore since 2007. He has been serving on the panel of arbitrators on the Brunei Darussalam Arbitration Center, South Asian Association for Regional Cooperation, Shenzhen Court of International Arbitration, Bangladesh International Arbitration Center, the BIAC, the Kuala Lumpur Regional Center for Arbitration, and the Singapore International Arbitration Center, known as SIAC. He is a certified international arbitrator of the Asian Institute of Alternative Dispute Resolution, a fellow of the Chartered Institute of Arbitrators in London, members of the ICC Commission on Arbitration, Paris, adjudicator in construction industry payment disputes in Malaysia, and also previously was a member of the ICC Court of Arbitration. Sir is also an experienced advocate in multiple jurisdictions, appearing before the High Court and the Court of Appeal in London, the High Court and the Appellate Divisions of the Supreme Court of Bangladesh, and also in domestic and international arbitrations and mediations. He has also been practicing from Selborne Chambers in London, where he's also a senior partner at A. Hossain and Associates, practicing in Bangladesh and Singapore, and A. Hossain Sarl in Geneva. Mr. Hossain contributed with his excellent arguments and submissions before the higher courts in England and Bangladesh, which resulted in numerous landmark reported cases involving different areas of law. He also acts as an arbitrator and mediator in cross-border and domestic disputes and sits on the disciplinary panels and tribunals with specialist knowledge of litigation arbitration and ADR, multi-party actions, cross-border disputes, debt and security recovery, commercial fraud, regulatory and fiduciary obligations, commercial documents, and also financial contracts. He has acted as sole arbitrator and co-arbitrator in several domestic and international institutional, trade, and ad hoc arbitrations. References include ICC arbitrations on contractual disputes concerning several multi-million-dollar power projects and multi-million contracts for the supply of aircraft, and a sole arbitrator appointed by the LCIA on multi-million claim on a guarantee, as well as co-arbitrator in the SIAC dispute relating to energy generation and waste disposal. He has experience of acting as counsel in arbitrations and mediations under institutional rules, including ICSID, ICC, LCIA, SIAC, GAFTA, FOSFA, LMAA, RSA, PORAM, and ad hoc arbitrations involving high-value and multi-party cross-border disputes involving governments, multinational, and domestic entities. He has also acted as counsel for and against banks, financial institutions, corporations, and others in many complex and high-value litigation, arbitrations, and mediations. Cases include claims arising out of transnational banking, trading, supply, and financial contracts. He has also acted as senior counsel in ICSID arbitrations for and against Bangladesh, including a bilateral investment treaty dispute, and for a multinational gas exploration company in a dispute concerning a gas field blowout. He has also acted as senior counsel for corporate clients in several institutional and ad hoc arbitrations in the financial, energy, and telecommunications sector. He has successfully challenged the Fifth Amendment to the Bangladesh Constitution, declaring martial law illegal, acted as amicus curiae in the Bangladesh Supreme Court in several high-profile constitutional cases, including the case concerning the 7th, which is the illegal military regime, the 13th, which deals with the caretaker government, and the 16th Amendment, Forum for Removal of Supreme Court Judges. As well as having expertise in the laws of England, Bangladesh, India, Pakistan, the European Union, and Singapore, he has also been involved in the drafting of several regulations and proposed amendments to the Arbitration Act of 2001. In Bangladesh, 2001 in Bangladesh, provided expert opinions. He has also provided expert opinions on the laws of Bangladesh, India, Pakistan, England, and the European Union, and has also appeared in the courts in North America, Europe, and Asia as expert witness. Ladies and gentlemen, without further ado, please put your hands together for Mr. Ajmalul Hossain, QC sir, AC sir, now on the stage. Thank you so much.
Honorable guest of honor, Justice Banani, our host, Muhammad Farooq Rahman, barrister, and distinguished ladies and gentlemen. It's an honor to be here in your presence this evening. Farooq, I have known for a very long time. As he said, going down memory lane, he started with me after he'd come back from England as a pupil. And at that time, I was doing a project for the central bank. That was the only time that I actually filled up a form and participated in a tender to be appointed as a lawyer. And so that was the only time in my life, and I somehow managed to get it. And Farooq was on my team, so he was always resident in Bangladesh Bank. I used to come and go. There were others in the team. There was a French company, a lawyer who was there. There was an Indian lawyer who was there. So we were a team of international lawyers helping Bangladesh Bank to become independent, use its autonomy in the right way. And Farooq, I know him from that time. He worked with me for many years, and obviously I must tell you that he was one of the brighter ones that worked for me. And of course, I can tell you this brightest will start looking for their own engine and become an engine driver. They do not want to sit behind the engine driver and just put something there. You know, they want to drive their own engines. And he's done that. Justice. And my chambers used to be in my father's residence, and it was a chamber which was set up by him more than 75 years ago. And at one time I used to stay there, and I used to meet Justice Chaudhary in the mosque. We used to go and say our Juma prayer in the same mosque. But apart from that, I saw him many times, because I appeared before him in the High Court division. And one of the cases that he and I disagreed with, or rather he disagreed with me, was the 16th Amendment case. So that was a case which relates obviously to, you may have heard of it, this relates to the removal of judges under the constitutional remit. So the process for removal of judges, originally in the Constitution it was down to the Parliament, members of Parliament removed. Then it was amended, and the Supreme Judicial Council was established. And then in the 15th Amendment, there was a change made, and it was that change which came before the court. And the court decided that the change was not justified. I supported the amendment, but their lordships decided against us. And of course, as lawyers, we have to accept what the judges say, and although we appealed, and also in the appeal, we lost, the judges were upheld. So that is the law at the moment. There is a review pending at some point in time soon. I hope that the review will be heard, and the Supreme Court will finally decide on the matter. Now, I have been asked by Farooq to speak alternative dispute resolution. And I'm conscious of the fact that I stand between you and dinner. So, I do not want to make my address to you too long, but I hope I can keep you entertained for a little while. Now, one of our colleagues, Mr. Rahman, very well-known senior advocate at the bar, he always used to say that ADR in Bangladesh means additional dispute resolution, not alternative. Effectively, he used to say that because under the old system, there was a lot of intervention in the arbitration process by judges and the courts. and a lot of time unhelpful intervention, if I may say so, with respect to His Lordship sitting here, because I'm sure in the course of the time that he spent on the bench in the High Court Division, he dealt with some of these arbitration matters as well. But that intervention really came from the fact that we had the old Arbitration Act of 1940, which was an act which was enacted by the English Parliament during the British times, 1940, following one of the laws made for England at that time. Now that act, obviously in those days, did not think about arbitration as an international phenomenon. Most of the arbitration that took place was domestic. So it was in one jurisdiction only, and it had provisions for appeal, challenging by way of an appeal and so on. That changed when the UNCITRAL model law came in, and the UNCITRAL model law suggested changes to the national statutes. And what we did in 2001 was amended, in fact got rid of the old Arbitration Act of 1940, and we have a new Arbitration Act of 2001, following the UNCITRAL model law. So this is a standard form of legislation which is prevalent now in most of the world, and caters for international dispute resolution. And that is where we come in now, and we are trying to use arbitration and mediation and other forms of alternative dispute resolution to augment the system that already exists in every nation, particularly in Bangladesh, for a dispute resolution. And the intention is basically to make access to justice easier, and for parties to have their disputes resolved without going through a hostile litigation in open court. So that is the objective. Now, in this context, what I'm reminded of is that some years ago, about 30 years ago, in England, there was a report prepared by the master of the rolls at that time, Lord Wolfe, and he called it Access to Justice. And he identified his remit. His task was to look at the English justice delivery system and suggest changes, civil justice delivery system, and suggest changes. He identified two evils in the English justice delivery system. The first one was delay. Everything took a long time to resolve, which is not unusual. We come across it every day in our practice here. And the other one was cost. It was very expensive. So he tried to address those two evils. In Bangladesh, we have two more evils. One of them has been referred to by my Lord Justice Chaudhary, vexatious litigation, abuse of process. And the second one is multiplicity of proceedings. The normal problem that we face with the delay in the justice delivery system, everyone attributes that to the increasing number of people, the population, less number of courts, and the fact that the system is to a certain extent old and archaic, which encourages delay. But the real difficulty, and I find this every day, and yesterday I was preparing, one of my juniors is here, he was there, in fact he was there this morning, and I was preparing the case, and I find that there are 17 sets of litigation, 17, 1 7, to resolve one dispute regarding one piece of property, 17. And I have found that most of the cases that I do relates to the banking and finance industry. And I have found that wherever there is a case relating to one loan, the parties end up with at least 17 or 18 cases. So if you have 17 or 18 cases which resolve one dispute, then you can imagine why the courts have a log jam, as Justice Chaudhary said. So I think the reason for that is the multiplicity of proceedings and a lot of abuse of process. And we see that every day, unnecessary litigation being brought in. Now, if you move away from the courts and go towards ADR, you are contractually bound to resolve your dispute in a particular manner. So you've got to deal with it either by arbitration or by a tiered dispute resolution clause. We call it a tier because the first tier may be negotiation, second tier may be mediation, third tier may be arbitration. So you have it resolved by an alternative method away from the courts. And the advantage of this is that it is not in the open, not in the public domain. So it remains confidential between the parties, and you can direct the pace depending upon which arbitrator you've got. Because litigation in our country, in my view, is not really driven by the clients or by the courts. It's driven by the lawyers. See, if the lawyers want to drive it fast, they can. If they don't want to drive it fast, they can also do that. And they can hold back that line. For whatever reason, that is what I find to be the situation. In England, Lord Wolfe ensured that the courts take case management as an important factor in resolving disputes. So the courts actually take the procedural thing in their hand and have case management conferences to make sure the case is proceeding in the way that you want it to proceed for an early resolution and as cheaply as possible. Now that is not happening in Bangladesh, because we need some changes in the law to achieve that. But if you want to go for ADR, you can easily do that. The arbitrators can do that. I know for a fact that I recently did, in fact, Farooq was representing one of the parties, and he is at fast track arbitration under the BAC rules, which has to complete within 90 days. So I was appointed the sole arbitrator, and I took on the job, although it's not that lucrative, but nevertheless, I said I'll do it to set the standard. And I did it in 90 days. So from start to finish, the whole dispute was resolved in 3 months. So if one wants to do it, that can be done. And I had a case, historically speaking, I had a case in Dhaka where a vessel was actually arrested. And it was sitting somewhere in the Bay of Bengal, anchored, could not go away because it was arrested. And there was an arbitration clause. So I sent a notice of arbitration under the SEAC rules, I think on the 2nd of January. And in that case, we had an award on the 1st of April. So we've developed a fast-track process, because every day that vessel was in anchor and arrested, it was causing the parties a loss of $10,000 per day. So it was a huge amount which was increasing day by day. So it can be done. So it depends upon a proactive arbitrator. Rules must be flexible enough. And if the parties want to have their dispute resolved, they can do it in a short time. And they can do it confidentially. There's one thing that I want to add in this context, which is that today, the public policy of Bangladesh, I would say, encourages ADR. If you look at the historical position, 20 years from now, before, in the year 2003, the Civil Procedure Code was amended. The Civil Procedure Code was amended to add several provisions relating to ADR. One was to encourage mediation, and the other one was to encourage arbitration. And why do I say that it's part of the public policy? Because since then, we've had many other acts, like the Ajmalul Hossain, Tax Act, the VAT Act, Customs Act, all of them encouraging disputes to be resolved by alternative means rather than going through the due processes. So as a result of all of these changes, it can be argued, and I have argued on many occasions before the appellate division that this is part of ADR, is now part of the public policy of Bangladesh. And the judges have accepted that. I remember one Chief Justice saying to one of the parties who wanted to challenge arbitration, saying, a contract করার জন্য আপনারা লিভারপুল যেতে পারেন, তো dispute resolution এর জন্য যাবেন না কেন? So this was obvious, you know. So the mood is changing. So from the old days where we had the intervention of the courts coming in, that is now stopping. So it's a move in the positive direction. So obviously, I think, and I'm being an ADR practitioner, I think this is probably the best way of resolving disputes. Mediations are very helpful because businessmen normally want to carry on with their business. Dispute resolution is not their business. It may be our business, but it costs them money, time, resources, everything. So for them, the sooner they get out of it and they carry on with their business, the better for them. So my view is that mediation certainly is a well-known phenomenon, and which provides a lot of, I think, high rate of success. And I can tell you this, at one point in time, I was in England. I had a diary, my diary was full for 6 months, pretty much. I knew back to back, I had several cases. And then of course the wolf changes came in, and we had to go to mandatory mediation. Now all my cases evaporated, all gone, because they're all settled by mediation. 6 months were gone. Now of course I had a little bit of a role to play. It was not dispute resolution through the court, but in the mediation also I appeared on behalf of the client and got some money out of it, but not as much as I would have if I did the cases throughout that period. So at that time I started coming to Bangladesh. And that was the time when we were getting into mediation as well. And there was a lot of concern by the lawyers saying, oh, if we go to mediation, what will happen to our work? What will happen to our business? But you see, in mediation also lawyers have a role, together with the mediator, to resolve the dispute. And of course, this is a consensual way of resolving disputes. And the idea is that both parties go away on a win-win basis. That's the general idea. Now in hostile litigation, you never get that result. Even in hostile arbitration, you don't get that. So there are many forms of alternative dispute resolution. You can have mediation, you can have expert adjudication. Sometimes someone goes to a lawyer and says, can you please give me an advice on this? Both parties say, whatever advice you give, I will follow. Both parties agree to follow that. So you have it like that sometimes. And these are the ways in which you can expedite the resolution of disputes. The other way, of course, is dispute avoidance. This is something that you have to anticipate, that if you are likely to end up with a dispute, how to avoid the dispute. And at the right time, when the big parties are still friendly and are talking, that is the time you want to engage and try and see if you can avoid the dispute altogether, not go to a lawyer and finish it, or even go to a lawyer and still finish it. So that is the sort of thing that businessmen really want. They want to get on with their business. They don't want to litigate, they don't want to arbitrate or anything. So if the solution comes in a way which avoids litigation, my suggestion and my advice will be, please take that. With that, thank you very much. I will end my speech.